Hello, guys. Welcome to today's live session. We're going to be discussing what's going on in US immigration. Please join in, and if you can hear me loud and clear, please type in the flag, type in USA, or you can use the emoji of the US flag so that I can be sure that you guys can see me and hear me well. Let's get started. If you can see me, hear me good, please type in USA. We have a number of topics to run through today. So please type USA or just put an emoji of the US flag in the comment section, and then it gives us the go ahead to get started. I will pull up the documents we'll be using today. While I wait for you guys to drop in your USA signal. Oh my gosh, I totally forgot that we're not on TikTok yet. Let me go live on TikTok now. Let's go live on TikTok as well. We're just live on these other platforms. Let's do TikTok. Oh my goodness. This is funny. Okay. So we just joined live on TikTok as well. Now we're live across all social media platforms. Please, if you can see me and hear me, type in USA. We're live on Facebook, on Instagram, on YouTube, TikTok, LinkedIn. All right, so now I can go ahead and share my screen. TikTok, you can hear me. Please type in USA, type in USA, type in USA. So the first point of discussion will be the update on the asylum fee for court. Don't worry if you are not, you don't have a case in asylum court. We have other discussions that you might benefit from. So just stick with us. So the Executive Office of Immigration Review, that's the federal agency that takes care of immigration courts, they released a new policy memorandum. I believe this policy was released on, was it January 2nd? Yes, it was a day after New Year's Day. And the effect of the policy was to give an update on the annual asylum fee, the new $100 annual asylum fee that everybody that has a case pending with, has an asylum case pending has to pay every year. They have to pay $100 fee. EOIR is saying that they will waive the fee, meaning certain people don't have to pay the asylum fee if you have an application that was pending for 1 year or more between April 5th, 2025 and September 30th, 2025, and your case was administratively final as of September 30th, 2025. Those people, they'll waive the fee, meaning they will not have to pay the fee. However, the immigration court or UIR will apply the fee to applications pending for more than 1 year as of October 1st, 2025. So if your case is pending in immigration court as of October 1st, 2025, for, let's say your case has been pending, you filed your asylum application in September 2024. As of October 1st, 2025, your case would have been pending more than 1 year with the immigration court. You will be required to pay your asylum fee. However, if your case was pending for 1 year or more and your case was final as of September 30th, then your fee will be waived. Administratively final means that your case has been decided, there's a final decision, and no appeal has been filed or no appeal was filed for your case within the required deadline, usually 30-day deadline. And so those fees will be waived. Let me see. I think I'm sorry, I was sharing my screen, but okay, let's see here. We won't cover everything, let me just go here and then we'll be done with the asylum fee topic. Just 1 second here. Okay. I'm not finding. I thought I had highlighted the portion. Okay, there you go. It's on page 4, I believe. Notwithstanding the foregoing, and to reiterate for clarity, EOIR is acquiescing to USCIS's position and will waive or forgive the annual asylum fee for any asylum application that was pending for 1 year or more. Oh, between July, why did I say April? It's July 5th, 2025 and September 30th, 2025, and was administratively final as of September 30th, 2025. So it was pending for 1 year or more between July 5th, 2025 and September 30th, 2025. And it was final, meaning there was a final decision by a judge, no appeal pending, no appeal was filed. Then your case ended, then you don't need to pay an asylum fee and an annual asylum fee because your case is now ended. So there's no point in you being made to pay that fee. Okay. So that's it. We won't go into all the other rants that the Department of Justice launched into a tirade of rants, and this memo was quite funny, but that's beyond the scope of what we want to discuss. So that's the update with the asylum fee. Let's move on. I'm sure many of you saw the shooting that happened. When was this? This week, a shooting happened by ICE, and a woman is dead. A U.S. citizen is dead. And I was reviewing some rules with regards to when can a law enforcement officer use a weapon, deadly force, those kinds of rules. Let's take a look at this. Usually, when I know many of you saw the shooting. There were multiple perspectives of the shooting incident, and it wasn't very, very clear because it looked a little dark, even though I believe it was in the morning. But sometimes I believe the winter conditions make things a little dark, or I don't know if it was people's phones. But it looked like there was a woman who was driving off, and there was an officer in front of her, and there was an officer beside her trying to open her door, and she was trying to drive off, and the officer in front of her shot her 3 times, 4 times, and the woman died. She's apparently she was a legal observer. I believe in Minneapolis there have been some immigration enforcement raids happening, and some of the protesters go there to protest, and some people are legal observers. They go there to make sure that the rights of the protesters are, nobody's violating their rights, and just, I guess, observe these protests. And there's multiple accounts of what happened. One account saying she was interfering with law enforcement. Obviously, that's from the Trump administration. And others saying she was just driving off. She had dropped her son off. It's quite unclear exactly what happened. But now she's dead. I understand she's the mother and the wife. And so it's likely that her family might bring an action in court to challenge the death, and to state that the law enforcement officer who killed her should be held liable for the death of the woman. And when it goes to court, they'll be looking at the constitutionality of what happened under the Fourth Amendment. Okay, they're going to be looking at whether what the officer did was allowed or is allowed under the Fourth Amendment. And you might ask, okay, what's the Fourth Amendment is the constitutional right that protects everybody in the United States from unreasonable searches and seizure. Okay, so if there's a claim that a law enforcement officer has used excessive force during a stop or arrest, that will be analyzed under the Fourth Amendment, where the Supreme Court's objective reasonableness test they'll use it. We'll talk about that So they'll look at, okay, this was a stop, it was an arrest, or it was a shooting by a police officer. If it's a stop, arrest, or shooting, it's a seizure. So the question they'll ask is, was the force used objectively reasonable under the circumstances? And that's what has sparked debate across the internet. Some people think it was reasonable, some people think she called for it, others are against it, that the death was um, preventable. I strongly believe that death was preventable, should not have occurred. But there's this raging debate, so they are going to assess whether the force the officer used, was it reasonable, objectively reasonable. Now let me share with you a case law that I was reading this morning, and that case was decided by the US Supreme Court in 2025, just last year. Let me see, did they put this here? Did I share it here? I don't know. I think I have it on my, let me share it on, it's for my device here. Please bear with me. Let's go here. Okay, this is the case law. It's called, I believe it's the case of, why can't I find the name here? I'm sorry, bear with me, guys. I have just pulled it up, and oh, Barnes versus Felix. Barnes versus Felix. Okay, there you go. I have it here. So let me share. It's a very interesting case that happened recently, and the Supreme Court, kind of gave us some guidance as to what to look out for when there's something that happens which has to do with a law enforcement officer discharging a gun or a weapon. And that's what I want us to just quickly take a look at. Let's see here. These are my books. There you go. I hope it's showing. Let's try again. Let me try again. Let's share this. Okay. Okay. All right. So you guys can see it now. This was Barnes versus Felix, and it was. Let's go over what happened here. Well, the summary was that, so Felix was the police officer. So the action was brought by Barnes, the man who was shot. It was brought by Barnes' mother, I should say. Obviously, Barnes was dead. Barnes died, so his mother brought the action, and it traveled all the way to the Supreme Court. I believe it was a certiorari to the United States Court of Appeals for the Fifth Court. Okay, here's what they held. So the Supreme Court said that because Felix could then have reasonably believed his life was in danger, that's a law enforcement officer, the panel held the shooting was lawful. Okay, now let me go here. So essentially, they held that a claim that a law enforcement officer used excessive force during a stop or arrest is analyzed under the Fourth Amendment, which requires that the force deployed be objectively reasonable from the perspective of a reasonable officer at the scene. The inquiry into the reasonableness of police force requires analyzing the totality of the circumstances. Let's go to exactly what happened in this case, and you guys will see. So it was in the afternoon of April 28th, 2016. So this was, the case went through. So it was a few years before there was some decision on the case. It was April 2016. Felix is a law enforcement officer, and he was patrolling a highway in Houston. He received an alert that there was a car that had an outstanding toll violation. When you pass through a toll and I think you don't pay the fees, perhaps that's the outstanding toll violation that they were talking about. So the officer, Felix, he spotted the car. It was a Toyota Corolla. And then the officer turned on his emergency lights to initiate a traffic stop. You know how they do it. The driver was called Ashtian Barnes. He pulled over on the highway shoulder and Felix parked his car. The officer parked his car behind and then he walked to the, you know how they do it, walked right to the driver side door and then he asked Barnes for his license and proof of insurance. Barnes said that he didn't have this with him. He said the car was a rental car in his girlfriend's name. So while the police officer was talking to Barnes, Barnes kept looking through a bunch of papers inside the car. And the police officer told him several times, stop digging around, stop digging around. The police officer said that he could smell marijuana and he said, was there anything in the car that he should know about? Barnes, the driver, said he had identification in the trunk. So Felix told him, okay, open the trunk from your seat. Then Barnes did so. He turned off his car engine and then, there was a dash cam recording of the incident. Okay, so then at that point, things began to escalate. So with his right hand, on his holster, that's the officer, he told Barnes that, get out of the car. Barnes, who's a driver, opened the car door, but he didn't get out. Instead, he turned the car engine on. Then Felix unholstered his gun, took it to kind of, took the gun out. And as the car began to move forward, the police officer jumped onto the door sill. Remember, the car door was open, so he jumped onto the door sill. And the police officer shouted to Barnes, "Don't fucking move." Because the police officer, I guess he couldn't see, his head was above the roof, he fired 2 quick shots inside the car. Barnes was hit, stopped the car, and Felix, the officer, radioed for backup. By the time the backup arrived, Barnes was dead. So on account, it said that there was just 5 minutes that elapsed between when the car started moving and when it stopped. Within that period, 2 seconds passed between the moment that the officer hung on the car door and when he fired the shots. Barnes' mother, that's the dead guy's mother, sued Felix on her son's behalf, sued the police officer on his son's behalf, and alleged that the officer had violated Barnes's Fourth Amendment rights by using excessive force against him. Okay. In the lower courts, they were saying that, well, they were going to use that moment of threat doctrine, meaning within the 2 seconds that Felix, the police officer, was hanging on the car, did he feel so threatened? He thought his life was in danger that he shot him. But essentially, the Supreme Court said, no, don't use that moment of threat doctrine. Use the totality of the circumstance doctrine. So they had to, I believe the case was remanded and to the lower court so that they could reassess the case using the totality of the circumstances doctrine. All right. Now, I was looking at a couple of, I believe it was a DHS memo. And no, not DHS, it's the DHS policy on use of force. Let's take a look at that as well. We're not obviously going to make any judgments or decisions here. We're just discussing. So feel free to share your thoughts as well in the comments. Let me share I hope I can find it on here because we uploaded it here. Okay, there you go. All right, let's see. Now, this is the DHS policy on the use of force. So it says that DHS law enforcement officers are permitted to use force to control subjects in the course of their official duties as authorized by law and in defense of themselves and others. In doing so, they shall use only the force that is objectively reasonable in light of the facts and circumstances confronting him or her at the time force is applied. So do you think that the officer's actions were objectively reasonable? Was there no other way? Could he not have moved away? Because if the argument was that, oh, the woman was going to run him over, could they not have moved away from the car? Were they trying to arrest her, or were they just trying to? It's just really unclear what was happening. But look at this. It says that if you look at the Fourth Amendment reasonableness standard, it says that because this standard is not capable of precise definition or mechanical application, its proper application requires careful attention to the facts and circumstances of each case. The reasonableness of a law enforcement officer's use of force must be judged from the perspective of a reasonable officer on the scene rather than the 2020 vision of hindsight in determining whether the force a law enforcement officer used to effect a seizure was reasonable. Courts allow for the fact that LEOs are often forced to make split-second judgments in circumstances that are tense, uncertain, and rapidly evolving. Okay, so the point is that when they're looking at objective reasonableness, they're not going to look at hindsight. They're not going to do a hindsight assessment like, oh, looking back, you could have done this, but they would attempt to place themselves in the shoes of the law enforcement officer to see that during that split second that the circumstances arose, was what he did reasonable? Consequently, there may be a range of responses that are reasonable and appropriate under particular sets of circumstances. Once used, physical force must be discontinued when resistance ceases or when the incident is under control. So look at that. It looks like the incident was under control. If they had moved, this incident would have been under control. I don't think that there was anything that made them very fearful for their lives that would lead them to shoot this woman. Now, look, it says respect for human life. They've been entrusted with critical mission. They must respect human lives. In keeping with the mission for human life, they shall continue to, blah, blah, blah. Okay, let's jump. De-escalation, use of safe tactics. Good. So it says that DHS law enforcement officers should seek to employ tactics and techniques that effectively bring an incident under control while promoting the safety of law enforcement officers and the public, and that minimize the risk of unintended injury or serious property damage. DHS law enforcement officers should also avoid intentionally and unreasonably placing themselves in positions in which they have no alternative to using deadly force. So if you go and place yourself in front of a car, you unreasonably place yourself in front of a car and you place yourself in danger, and then the car is moving, do you think that's objectively a technique that a law enforcement officer should employ? It says it right there. You don't use tactics that will be unreasonable such that you don't have any choice but to use deadly force. So you know that if you go put yourself in front of a car and the car is moving, you could be killed. And so you will now use deadly force so that you say that, oh yeah, the car was going to hit me, so I use deadly force. Don't unreasonably place yourself in that type of position. Okay. So there's a few discussions on how they can use warning shots and things like that. All right, so I these are some of the things that we can start to think about. I don't think that this will be the end of obviously this matter. It's really garnered a lot of national attention, so we'll be hearing more about it. So these are some things that we can start to look at and discuss. Okay, now let's move on to our next topic. But before we do, it's just really important that in protesting, protesters also look out for themselves. They have to understand what their do's and don'ts are, and just make sure that they're not placing themselves in harm's way. And I hope that the ICE officers are also properly trained and they actually adhere to the training they are giving not to use unreasonable force when they can de-escalate situations and using other non-deadly alternative force. Okay, there is information that San Francisco's main immigration court is closing by the end of 2026. This was reported by a news KQED, and the court began in 2025 with 21 judges, but now just has 4 judges remaining. Apparently 13 were fired, 4 more retired at the end of 2025. And some attorneys have mentioned that the people that retired were actually pressured to retire. And nationwide, you guys know that last year more than 100 immigration judges were fired. So that's for your attention, the people who may be in San Francisco. All right. Now let me see if we can take a few questions. But before we do, I also want to bring your attention to the fact that there is an aggressive campaign by ICE or DHS, of DHS against people who are visa overstayers. And I'll just explain that the fact that you have an immigration case pending with USCIS does not totally protect you from ICE enforcement. You can still be detained, and you can still, you can still be arrested, you can still be detained, because you're removable. So long as you are not in lawful non-immigrant status, you can still be removed. Okay, so just bear that in mind. You guys know that this, I believe we discussed it right here. There was a visa overstayer that was involved in some shooting, and that put the radar on visa overstayers. And so USCIS, DHS released an announcement saying that they were going to go after people, people who had overstayed their visas. We're discussing this in response to people who keep asking that, oh, I have an application pending with USCIS, am I at risk? Generally, no. In the past, ICE would prioritize enforcement, and they would usually target people who were enforcement priorities, like criminals or people who had enforcement priorities, like just depending on what each government is looking out for. For Biden, it was like people who entered into the US without inspection, without a visa after a certain date. I believe it was after 2021, sometime in 2021. But for Trump, his enforcement priorities are not very clear. One minute they say, oh, it's criminals. The next minute it's like, oh, everybody's game, so long as you've overstayed your visa. So if you have overstayed, you have an application pending, it's in your own interest to make sure that you don't do anything that will cause law enforcement to encounter you or interact with you and put yourself in trouble. All right, let's see. I think we have some questions here. Shara May Sanchez says, can I ask about CISPA? Yeah, the Child Status Protective Act, we've talked about it several times right here on this channel. If you have a CISPA question, please set up an appointment, because CISPA, we have to use some calculations. We have to get all the dates right and do the mathematical calculation to assist you to see if CISPA applies to you, and if your immigrant's visa category has changed, and if you can still be considered a child for CISPA purposes. So please make sure you contact us. This is not an analysis we can do on a live session. Okay, thank you. Okay. Nanoste Owusu says the constitution must duly be looked into. I agree with you, and I believe this is in regards to the shooting, the killing of the woman. Absolutely. I'm sure probably her family might sue. Who knows how this will play out? Let's see how this will go. This is Say Bukhari says, my case is refused under 221G administrative processing for more than 1 year without asking for any additional documents for family immigration visa. Would you kindly let me know what to do? What country are you from? Please contact us so we can look into this for you and assist you. Administrative processing 221G. It's a big black hole. If you get in there and you don't take certain steps, it can last for several years with no end. Okay. All right. Lauren Wajuoba says, good evening from Nigeria, ma'am. Would like to know whether K1 is banned because USCI has already approved my case and I'm waiting for my tracking number from NBC. Well, yeah, Nigeria, Nigeria is a partially banned country. They are banned as to all immigrant visas and partially banned as to particular non-immigrant visas, B, M, F, and J. They don't mention K1. K1 is technically a non-immigrant visa, but I mean, K1 is always in between because essentially, if you're coming in on a K1, you are immigrating, but it's categorized as a non-immigrant visa, but processed as an immigrant visa. So it depends on, the consulate, but I believe that from Nigeria, they are granting K1s despite the ban because K1 is being seen as a non-immigrant visa. So you likely, it looks like you said you are waiting for tracking number from NVC. Okay. Well, yeah, just contact us and let's see how we can assist you. Okay. Angela Agori says, hi, Ikea, been trying to reach you. Please, our numbers are right there. Please contact us and we can assist you. Okay, 802-780-0564. Okay, and we can discuss what's happening with you, and I can give you the one-on-one attention that your case deserves. Chocolate MD on TikTok says, I-140 is still being processed for the banned countries. I-140 petitions are not being processed for the banned countries. Remember, there's 39 countries and there's an immigration freeze or an adjudicative hold for nationals who are applying for any immigration benefit from those 39 countries. So if you're from one of the 39 countries, unless you can claim an exemption from the adjudicative hold, your country will not be processed. I'm sorry, your case will not be processed. I mean, well, you'll not get a final decision, is what I should say. It's going to be processed, but there's not going to be a decision on the case. Two Phil says, please, you don't return and answer my calls. Please call us 802-780-0564. We will do our best and text us, okay? We get overwhelmed, so please just call, text, and if we happen to miss your call, just call us again. We'll try to respond. Amaya Boa says, please, how long does VAWA take? Please, how long does VAWA take? I submitted my documents in July, but I haven't heard anything. VAWA takes some time. When you submit your application, it can take several months for you to get a receipt notice. And then the VAWA itself can take about 4 years to be processed, between 3 to 4 years to be processed. So it takes a long time. Sarah Sanchez says, send your message. Will I have to pay a consultation fee? Yes, our consults are not free because they are cutting edge. By the time you're done with the consults, you'll have all the answers you need. You'll leave with clarity. So they are worth it. We have so many people trying to get legal advice, and that's how we're able to keep the organization running. So please, yes, that's legal services. Okay. So yes, our consults are at a fee, but they are very, very worth it. Okay, let me see if there are any more questions on TikTok. 12 Phil, can you text us again and I'll make sure that I have somebody from the team reach out to you. Lady D said, how much you charge for consultation? Please call us. It depends on what your case is. For example, if we're doing a deportation defense consultation, it's different from a family-based, where your family member wants to file for you. If you have a denied case, then there's a different fee as well. Okay, so we have Monica Novak says, "Hi, I went to my marriage-based interview back in May 2025. They separated us and gave us a white piece of paper at the end. They said it will take 120 days for the review. It has been more than 7 months. Nothing from USCIS. My husband filed the petition for me in October 2024. Can I do anything based on that piece of paper I received? Please contact us again and let's review what's going on. Sometimes we can send a pre-mandamus letter to let them know that we're planning to sue them. But it depends on the fact of your case. If your case is, you don't have a very strong case, and we're going to be relying on the discretion of the officer to approve it, where your case falls in a gray area, then it becomes a legal strategy. Should we go ahead and threaten them with a pre-mandamus letter or not? And after we threaten them with a pre-mandamus letter, then we can file a mandamus to ask them to work on the case. But all of that depends on a lot of factors. So contact us and we'll see what's going on with your case and why they separated you. Typically, when they separate you and your husband, that's called a Stokes interview, meaning that they don't believe that the marriage is bona fide. There are usually red flags that lead them to separate you guys. So we'll review everything and then we can assist you with exactly what we need to do moving forward. All right, guys, thank you so much for joining us. I appreciate each and every one of you. It's been a pleasure having you here. I hope that I'll be seeing you next week as well. I'll have to hop off. Let me see. Did I have any Instagram messages? Yeah, there's a bunch of them, but it's really difficult to read these days because of the StreamYard that we're using. Now I don't go live directly on Instagram. We go through StreamYard, so it becomes tough. All right, guys. Well, thank you again for joining us. My name is AK Poku, U.S. immigration attorney. If you need our help, we do offer in-person consults, video consults, phone consults. Just contact us and we can make time for your case. It's been an extremely tough period in immigration for the past several months. I'm sure many of you are aware, so please bear with us. If you call us, you don't get us, call us again. And please follow the processes that we've put in place because that's how we're able to maintain sanity and assist our clients. All right, thank you all so much for joining. And if you have not yet followed AK Poku across social media platforms, make sure you follow us across all social media platforms. I'll see you guys soon in our next live session. Have a great weekend. Take care. Bye-bye.